An overview of the First Amendment as it applies to signs. And of course, there are all sorts of signs that serve all sorts of purposes. But here's the First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, or abridging the freedom of speech or of the press, or the right of the people peaceably to assemble and to petition the government for a redress of grievances. With the 14th Amendment, which was passed in the latter part of the 19th century, the first 10 amendments to the Constitution were extended to the states. So you can read this now. Congress shall make no law. The state legislature shall make no law. City council, the county commissioners shall make no law. So this applies to all of them. As you probably remember from your American history courses, or maybe not, the original emphasis of the provisions on freedom of the press were on what we think of as the press. Now, Benjamin Franklin's, they called them tracts, were a little different shape and a little different color than our modern newspapers, but they served the same purpose. They expressed opinions about the government and tried to create a dialogue on public issues. And that's really where we started with the First Amendment. And we still do that today. Here are some examples. I'm actually not sure what the sign on the left means, but it's clearly an expression of opinion about something. It's perfectly legitimate. In the middle, we have an expression of opinion about a church. Can't find all your answers on Google. And on the right, we have more classical political signs. So we still see the First Amendment protecting this kind of speech. But really, for about 175 years, the whole focus of the First Amendment was on this political kind of dialogue, this public kind of dialogue, until we had a series of 3 very important cases that decided that the First Amendment protected not only expressions of opinion, discussions of public issues, but also commercial speech. And that's why it's so important to think about the First Amendment in the context of sign regulations. The Virginia State Board of Pharmacy versus Virginia Consumer Council said that the state could not prevent drugstores from advertising prescription drug prices. Up until then, many states had prohibited that. Today, we're used to being able to go on the internet and check prices on things. You couldn't do that before. You couldn't do that in some states before 1976. And the Supreme Court said, no, the Constitution protects that. Until 1977, most states prohibited lawyers from advertising, not by state law, but by rules published by the state courts or the bodies that regulated attorneys. 1977, the Supreme Court said you can't keep attorneys from advertising. I'm not sure that was a social advance if you look at some of the billboards for attorneys today, but constitutionally it's undoubtedly right. 1996, perhaps socially less useful, but still important to some people, the Supreme Court held that the state of Rhode Island could not prohibit liquor stores from advertising liquor prices. And of course, I don't know about where you live, but where I live, the weekend papers often have extensive ads for liquors with prices on them. Now, I'm not going to provide full citations to cases as we go along today, but there's a separate handout for this session that will give you full citations to all of the cases and a little bit of other valuable information. So, today, commercial speech is clearly protected by the First Amendment, including all of those ugly signs out there. And we're going to talk about, and some pretty signs, and we're going to talk about exactly what that means. Now, before we start talking about some cases in which the courts have struck down sign regulations, and, well, we just talked about some, they weren't sign regulations, but the court's striking down regulations. Sign regulations themselves have long been upheld. The United States Supreme Court first upheld zoning as a constitutional exercise, constitutional form of regulation in 1926. In 1911, the Missouri Supreme Court upheld sign regulation and said it was constitutional. Thomas Cusack Company versus Chicago, 1917, the U.S. Supreme Court upheld sign regulation. So in principle, the courts have long upheld sign regulations. What we're looking for are the limits, not the question of whether they're valid, but the limits and where we find those limits, and that's what we'll talk about today. In a much more recent case, I think it was 1981, the Supreme Court noted signs pose distinctive problems that are subject to municipalities' police powers. Unlike oral speech, signs take up space and may obstruct views, distract motorists, displace alternative uses for land, and pose other problems that legitimately call for regulation. Here we have the Supreme Court making a very strong statement about the importance of sign regulations. But again, what we're looking for is this balance. How does the scale get tipped when we go to court? Ladue lost, and let's look at why. In a normal zoning case, if your local zoning ordinance says that bowling alleys are only allowed in a suburban commercial district, and someone wants to put a bowling alley downtown, and they sue your local government and say, this is totally arbitrary, maybe it's unconstitutional that you do not allow bowling alleys downtown, and you force us out to the suburbs. When you go to court on that case, when your attorney goes to court on that case, the local government enjoys what's called a presumption of validity. You go into court, you come out of court with the presumption that your ordinance is valid, that the city council knew what it was doing, that it had a good reason for doing it, and that's measured against what's called a rational basis test. So if the members of the city council, they can come in and say, well, our experience has been that bowling alleys attract a whole lot of people on Saturday afternoon and they create parking problems, and we don't want those downtown. We'd rather have them in the suburban parking area. Is that totally crazy? Hey, the downtown's probably empty on the weekend. Maybe that'd be a good time to have parking downtown. But city council gets to decide that. That's what the rational basis test is. Even if you could argue that they're wrong, they get to make that decision. But when regulations are based on content, and we'll look at a couple cases involving that, then the whole system shifts and the courts apply a rule called strict scrutiny. And the basis of strict scrutiny is really that the local government is presumed to be wrong because it is adopting content-based regulations, and so the local government goes into court with a very, very heavy burden of proof. And that's extremely challenging. It makes the cases tough to win, and we'll look at why. Ladue lost the strict scrutiny test. This was the early 1990s, and Mrs. Galeo put a sign in her front yard that said, "Peace in the Gulf." That was the first Gulf War. Code enforcement official came along and said, you can't do that. And she could have had a real estate sign in her front yard. Think about that. The real estate sign's commercial. Here she's expressing an opinion, just like Ben Franklin, on a matter of public issue. But the code enforcement official says, you can't do that. She was actually a very good sport. She took the sign down. She made a paper sign with the same message and stuck it in her front window. The code enforcement official came along and said, you can't do that either. And this was such an important issue to the city of Ladue that they began a prosecution that they ultimately took all the way to the U.S. Supreme Court, pretty much losing all the way. And they lost in the U.S. Supreme Court because here she can have a legal sign that advertises a commercial product, her house for sale, but she can't express her opinion on a matter of great public interest at that time. So, of course, Ladue lost and Mrs. Galeo won. That concludes this chapter. In the next chapter, we'll look at the issue of making sure that sign ordinances actually relate to issues that public officials want to solve and the ones that they say they want to solve. And many local sign ordinances don't meet that simple test.